Good morning and welcome to today's webinar, The Essentials of Estate Planning and Elder Law, presented by Elville & Associates Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer and I'm the Community Relations Director here at Elville & Associates, and I'll be moderating today's event as always. So how this will work today, if you're new to our webinars, and I see we have a number of new faces, so welcome, we're glad you're here. And if you're coming back to see us again, as always, thank you for being here as well. So you as the attendees are currently in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address your questions. And we always encourage questions here at Elville & Associates during our presentations. They help others learn, so please don't be shy in posing your questions at any time. You received the presentation by me yesterday through email to take notes on it if you wish. And if you didn't receive the presentation for some reason, I see we have a number of people that just registered for the webinar within the last few minutes. It is in the section marked handouts on your panel on your screen to download at this time. And as always, for CFPs, CPAs, and other professionals on today's webinar, you also may receive 1.5 continuing education hours for attending. So per my attendance records requirements, please email me your board ID. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval, which I'm going to do on Monday. Everyone will also receive a post-webinar feedback email right after the presentation. And we do ask that you please just take a couple minutes to fill out this really simple survey. Offer us your feedback and comments about the presentation. We value your feedback and we do read every comment. It's also an ideal time to request a consultation with Steve if you or your family have any planning needs at this time or have some documents that you'd like us to review, and we don't charge for those consultations. And we always look forward to being a resource to you here at Elville & Associates now and in the future. So briefly, as we have a lot to cover, I'd like to give you just a quick overview about our firm and Steve, if you're not familiar with this. So you should be able to see my screen right now. So Elville & Associates, we were founded in 2010 by Mr. Stephen Elville. We have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, which works very closely with the rest of our practice areas, and also tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location right now. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do offer a lot of education here at Elville & Associates. We do that in a number of ways through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities we serve each year. And also, by way of our accredited client care program, or CCP as we call it here, we're one of only 2 firms in the state of Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client, every time, every day here at Elville & Associates. A little about Steve, managing principal and lead attorney of our firm. His work as an attorney for the past 22 years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, he works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard him talk before, and presenting at many webinars, workshops for businesses and their employees, and many continuing education events. Also this year named to the Maryland Super Lawyers list for a 7th time in 2022 and a 6th consecutive year. So congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014 and I am privileged to be the executive director of as well. If you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, feel free to reach out to me and I'll be happy to talk all day about it with you. So with all that said, we're going to go ahead and get started. If I can just get back to my screen here. Steve, I'm going to make you the presenter, but first, actually, we're going to start off with a brief poll just to see what has brought you to today's webinar. And your choices, if you'd like to take part. And again, the question is, what brings you to today's webinar? Is I am new to estate planning and need to get started. Second, I have a plan in place, but it is outdated and needs updating. Third, I feel my plan is on solid ground, but education is great. And lastly, I'm an advisor here to learn to better serve my clients. So welcome to our financial advisors that we also have here on our presentation today. So just take a few seconds to make the choice that best suits your situation so we know who we are talking to today. We'll give it a few more seconds. Okay, with about 2/3 of the votes having been tallied here, we have 47% saying I am new to estate planning and need to get started. So welcome. We have 12% saying I have a plan in place, but it is outdated and needs updating. That's not abnormal, as we see here at the firm. We have 18% saying I feel my plan is on solid ground, but education is great. And 24% say I'm an advisor here to learn to better serve my clients. So very good. Thank you for participating. Steve, I'm going to make you the presenter. You should see the button pop up there.
Thank you, Jeff.
All right.
I'm just going to hit that button there. And there we go. And now I'm going to go to my desktop, Jeff, and hopefully my presentation is sitting right there for me. There it is. Can you see that, Jeff?
Very good. I can.
All right. Good morning. And I'm just going to start my slideshow here. Very good. Thank you. And good morning. Thank you, Jeff. Good morning, everyone, and welcome to our Friday webinar. I'm Steve Elville. I am the principal and lead attorney of Elville and Associates, and I'm privileged not only to lead Elville and Associates, but to be here with you this morning. So we take our responsibility of education very seriously here, and we're going to talk about that a little bit further. Thank you for spending your time this morning with us. We know you're very busy and have other things you could be doing. It's a beautiful day. I think spring might be in the air a little bit, but Jeff told me no, it's going to be cold again next week, but we'll take this little bit of warmer air here this morning. So today I'm going to lead you through a discussion. Jeff is a wonderful moderator. He and I have worked together for years. I couldn't do these presentations without him, and he is going to take your questions, make sure you have the information you need, troubleshoot any problems you may have during the presentation. We hope you won't have any problems, but basically be here for you. And our purpose again today is to educate you. But we also not only want to educate and help people learn about what I would call these essentials of elder law and estate planning, but we also want to provide a path forward. We want to not only educate, but we want to show you how to take action, how to do these things. And many times these are roadblocks. As I get older and I've practiced law for many years and have had thousands of clients, I now understand more than ever that it's very difficult to decide to get started in this process. It's very difficult to share information that you have about your personal issues and your desires and your dreams and your hopes for your family, and sharing this kind of information is not easy. And there is a fear factor. There is a possibility that maybe this is a fearful subject, something that's not easy to take the first step. So we're very aware of that. We want to not only educate you today, but again, to give you a path forward. And I know many of you on the call or the webinar this morning have never done estate planning. Welcome. For those of you who have done estate planning, you know a little bit about what it's about. And I just want you to know that we're here to review existing documents and to help those of you who have already planned to take a look at what you've already done years ago and see if we need to do any updating. But with that said, we're going to get started. And I just want to say one last thing. This is a lot of information, so please don't be overwhelmed. And my advice to you about this information is to look at it as kind of a mini master class. A mini masterclass on estate planning and elder law. And if you can take away some concepts from this today, if you can take away 2 or 3 things from this that you substantively know that you've grasped this, and you can use this presentation as a tool, you can use it as something you can refer to in the future, you're going to know more than about 95% of people in the world know about estate planning. So there's some powerful information here. It's very broad. Don't be overwhelmed. Make sure you ask questions if you have them. Jeff and I will stop every once in a while to see if there are questions. And with that said, we're going to get started. Thank you for being here, and we appreciate it. Okay, so we're going to talk about what is estate planning and what is the process of estate planning. You're going to hear me talk about process, and process is important. Again, the older I get and the longer I do estate planning, the more I realize that process, including the way we do it here at Elville and Associates, of course, is very, very important. And without process, we go to point number 2 here, that estate plans can actually fail if we don't have process. You can have a great estate plan, you could have the most wonderful estate planning documents, but if you don't have a good process, which we're going to talk about in a few minutes, your plan might not work the way you exactly want it to work. We're also going to talk about wills and trusts, one of the biggest questions that people have in the country. In the United States is, what's the difference between a will and a trust? What this boils down to many times is, what is probate versus non-probate? So we're going to talk about that. We're going to talk a little bit about elder law. We're going to talk about taxation and asset protection planning. These are broad terms. We can't possibly go into all the details about these very broad subjects, but I'm going to do the best I can to tell you what's going on today with these issues and what are the major things you would want to be concerned about. If you've never done planning before, we might not be concerned about all of these things. But what we do here at Elville and Associates is we make sure that we are letting clients know all of their contemporary choices. And we are providing counseling along the lines of all of the choices that are available in modern estate planning. Some of them are going to apply, many of them will not necessarily for each situation. And we're going to talk about getting started, how to take the next steps, how to do it without being concerned or fearful, and we're going to continue from here. So let's start by trying to understand, what is the estate planning process? Well, it should be a process, and you should have a purpose. You should have a goal. All estate planning is goal-driven. All tax planning is goal-driven. All special needs planning or asset protection planning, elder care planning, all of it starts with a goal. If we know what the goal is, we can generally get from point A to point B. Again, this is critically important, although it sounds very fundamental. So we have to know why we want to plan, and we also need to be aware about what I spoke about earlier, that many plans can not work quite as well as they're supposed to, or they can actually fail altogether. So we want to understand why that is. So as you'll see throughout this presentation, sometimes I will mention a topic and then I will mention it again. And that is because I want to drive home these issues. I want to drive home these key points. So we want to have a purpose. Your purpose is going to be different from someone else, perhaps. All planning is goal-driven, so we want to have a goal. We want to have a purpose. Now, these are just some of the topics that or some of the purposes or goals that you might have. Some of us want to provide certainty. Of course we do. We want to provide certainty for our loved ones, for our spouses, for our grandchildren. Some of us are driven by smooth administration. A client will come in and say, Steve, I'm here because I want to make sure things are as easy as possible for my kids, for my grandkids, for my spouse. Some people are driven by minimizing costs. Some people say, how much is this going to cost? But ultimately, how much is the whole thing going to cost from the time I do my planning until the time of my passing? This is taking into consideration all the costs of planning. Some people are driven by asset protection. That's the goal. I want to protect my spouse. I want to protect my kids and grandkids. I want to protect my nieces and nephews from bad marriages, creditors, bankruptcy, car accidents, all of those things that can sometimes happen in life. Some people are tax driven. I want to minimize taxes. I want to make sure that I'm addressing all of the taxes, all of the tax issues. And there are several types of taxes, of course, and we're going to talk about that a little bit today. So again, we may have special purposes. We may have something that's not conventional. There's something that's happened in your life. You might have a special needs child. You might be concerned that someone that really isn't disabled is potentially going to become disabled. Lots of different things that are going to drive you and you alone. What we want to do in planning is take the time to think. We want to take the time to help you formulate what your goals are. And then once we know what those are, we can pretty much move forward in a straight line to get to where we want to be. Now, one of the problems in estate planning as we try to figure out process is what kind of process, or is there no process? So let's talk about this first little bullet point up here, that attorneys and clients tend to treat estate planning not as really a process, but just as a set of documents. I have a will, or I have a trust, or I have a power of attorney document, and there it is. It is it's a hard copy. I have a copy. I have it in my safe deposit box, or I have it in my closet at home, or in my safe. We are here today to tell you that that is not an estate plan. It looks like an estate plan, but that is not a process of estate planning. That is just a set of documents. And we would call that traditional planning. That's how I was trained in the business that we are in today. I was trained just to focus on documents and not on a lifetime process. So we don't want to forget that this is a lifetime thing that we're involved with. Most people don't think of it that way, and I want to encourage you to think of estate planning as a life process. Now, why do I say that? Well, most people don't have any estate plan. I'm going to let you think about these statistics for just a minute, but I'm going to ask you a few questions. How many people in the United States have estate planning, a will or a trust? How many people? Well, as you think through that, I'm just going to tell you it's about 55% do not have a plan, and only about 45% have a plan. And in some demographics, people that are, they're divorced, single people, they might be as high as 62% of people in this country have no plan. So most people in our country have no estate planning, and only a minority of people have estate planning. So I'm just going to ask you rhetorically, do you believe that? And I think most of us would believe that. That's what the statistics show. But if we look at this bottom bullet point here, we see that even those people who do have planning, these are people who are the minority of people, the 45% or less. Most of those people don't follow up. Most of those people don't update their estate plan. And this statistic right here is how many years go between visits for those people who actually do estate planning. How many years go by before they update? Well, the answer is 19 years. That's what we know from the National Network of Estate Planning Attorneys, which is an older organization from the 1990s that still exists today. They say that it's about 19 years at a time. Would you believe that? And I think most of us would believe that. We who actually do planning, we tend not to focus on updating. So I'm going to tell you today that process is very important and updating is very important. Now, are there times when someone just needs a set of documents and they need it quick? And the answer is yes. People need wills, trusts, powers of attorney, and they need them quick. Someone is traveling, someone is getting ready to pass away, someone is ill, someone is almost disabled and they have to have a power of attorney before they become totally disabled. Yes, all of these things are urgent situations. There's always exceptions to the rule, but if we had our time, if we had our druthers, if we had our choice, we would always want to engage in a process rather than just a stagnant situation, whereas what I would call a traditional estate plan. So the traditional estate plan is generally not driven by a process, and we don't want that. We want this non-traditional plan. We want a broader plan that's going to think about or consider all of our life issues throughout the rest of our lives, not just a one-time transaction. And again, I'm not going to spend a lot of time on this now, but this is a tool for you to use, understanding that a typical estate planning situation is limited to just one phase. And that phase is really implementing a set of documents. There's typically no education, there's no maintenance or updating, and so forth. So this is what we don't want, because this is the beginning of the problems that occur as we continue to age and as we continue to go through life. What we would prefer and what we want to focus on today is a process. And I'm going to show you a 3-step process, although the number of steps really doesn't matter. What matters is that there is a process. And here we're talking about designing a plan, taking the time to think. About 2 years ago, when we were in the middle of COVID, Jeff and I were talking and we said, you know, one of the biggest problems that attorneys see, and there are 6 attorneys here and 2 special counsel attorneys, is that people don't have enough time to think today. They're overwhelmed. We see this especially with families with a loved one with disabilities, but with all families. So we want to take the time to think, the time to design and implement our plan. Then we want to maintain that plan. We want to update that plan and in some kind of a reasonable way throughout the rest of our lives. And then at the time of our deaths, the time that the plan actually matures and the plan is actually administered, then everything will work much better than it would have otherwise. Or it may work perfectly, and that's our goal. We want our planning to work perfectly at the time of our administration. So a process-driven estate plan, in our view, is an educational process, and it incorporates all 3 of those major phases. The emphasis is on education. There's a life process. There's maintenance and updating. Now, for those of you who are on the call this morning and you've never done estate planning, you are looking to do your estate planning, this can be overwhelming. So what I would like you to do is just think in terms of, yes, I need to do planning. Yes, I need to take the first steps forward. And I'm glad to know that process is important, because now I know that, but I don't want you to worry about the process. I know how overwhelming it already is to consider coming and doing your estate planning. So please don't be overwhelmed by the process. Just take this as education, that this is an ideal best practice. So we want to define estate planning. What is it? Well, you're going to have your own definition, I believe. And I'll just tell you this morning that estate planning is generally about, and you can use this definition if you would like, disposing of property, disposing of your property, the way you want, to the persons or organizations of your choice at the lowest possible cost. So I'm going to read that again. Estate planning is about disposing or giving your property the way you want to the persons or organizations of your choice at the lowest possible cost. I would advise you, or I would encourage you to think about this definition and then expand it for yourself and say, what are my goals? What is driving me to get this estate plan in place? What am I worried about other than COVID-19 and the obvious things that people are worried about today? What is driving me here? And let that sink in, and we'll go from there. Now, many people on this call this morning are concerned about understanding wills versus trusts. So again, this discussion is really about probate versus non-probate. But before I continue, I'm just going to stop and take a brief sip of water here and ask Jeff if we have any questions so far.
Thanks, Steve. Don't appear to be any questions at this time.
Thank you very much, Jeff. Well, we're just getting started, so I'm not surprised by that. So a will, a last will and testament, is subject to the probate process by its very nature. So let's talk about wills. Wills are going to be subject to probate because what is probate? Probate is the process of proving the will to be valid. That's what the whole process is. Now, if I don't have a will, can I still have probate? And the answer is yes. I can still have probate because if we don't have a will, then the state of Maryland will say, well, this person died without a will, and therefore the state of Maryland's intestacy laws, the laws of intestate succession, will say how the assets are distributed. So generally we want a will, and we want the will to articulate how we leave our assets. But the first thing we have to realize is that the probate process is subject to public oversight. So that's what the registers of wills and the orphans courts that are attached to the register of wills, that's what they do. They look at the will, they notify everybody, there's a process, all creditors are notified, and there's this administration process. And so the will by its very nature is subject to probate. Now, are all assets subject to probate? And the answer is no. So let me just ask you, because I can't actually see you, but I will ask you to think about these things silently or write them down. If I have a money market account, and that money market account is in my sole name, it's in my sole name with no beneficiary, is that subject to probate? And the answer is yes. That asset was in my sole name with no beneficiary. It's subject to probate. Okay, so that has to go through the probate process. Second or third example here. I have an IRA, and that IRA has my child or my niece or nephew as my beneficiary. Is that subject to probate? And the answer is no, because that is a beneficiary designated asset. It is not going to go through probate. Now, what if I have a life insurance policy or an IRA or both, and none of them have a beneficiary? Then those assets are subject to probate. So we first have to ask ourselves, what is subject to probate? And my last example would be, if I have a home and it's jointly owned with someone else, whether it's a spouse or not, does that go through probate? And the answer is no, that's jointly owned. But if I had a home in my own name or a rental property in my own name and I died, that would be subject to probate because it's in my sole name with no beneficiary. So that's what probate is. Whether I have a will or not, I'm going to be subject to probate if I have probate assets. So this slide shows a very compact example of what probate is. The estate is opened, there's an inventory, creditors are notified, there's an accounting that's due, usually, unless it's a modified estate, and then there is administration, a final account, and the cost of probate is around 4 to 7% according to AARP magazine. So this includes states like California and New York. I would say in Maryland, the average cost of probate is around 4%. And the reason I'm saying that is if we look at the commissions and the fees that are allowed in probate, generally they are around 4%. And we won't go into the formula today, but there is a formula that talks about these fees. All right, let's look at what a will structure is. So I would look at this structure as kind of a three-legged stool. We have the will, and the will is the driving force. That's the driving force of the plan. For those of you on this webinar who have minor children, this is the big concern for you if you're a young couple. And I'm calling anyone under 45 years of age young. And the average person who's 44, 45 years of age or younger, about 80% of you don't have wills. So I'm just talking to you right now because if you have a will, the most urgent concern that most parents have is providing for a guardian for minor children. So that's what we would do here with a will. So the will's a driving force. If you don't have minor children, then we would look at other provisions for children. But notice on the left and right of the will here, we have powers of attorney and advanced medical directives. So in estate planning, we are doing actually two things. We are taking care of what happens at death with the will. We're also taking care of what happens during life. Many people are living a long time. We've had many clients here at Elville and Associates live to over 100 years of age. Lots and lots of clients live into their 90s. So we're likely to live a long time. The powers of attorney and advanced directives are in place to deal with what? The issues surrounding incapacity. So what happens at death with the will? What happens during life with the powers of attorney and advanced directives? Now, some people don't want a will, or a will is not appropriate for them, but a will substitute is appropriate for them. So that's what a revocable living trust is. A revocable living trust, if you've never heard of this, or even if you have, is nothing more than a substitute for a will. It is a contract, basically. So when I'm looking at basic estate planning, I can get a will, put that will in place. That will is perfectly fine in most cases. Or if I want a will substitute, and why would I want that? Why would I want a will substitute, which is a revocable trust? Well, usually it's because I want to avoid probate. And that's what I want you to know today. The real fundamental reason to use a revocable living trust versus a will is that the revocable trust, if it is done properly, meaning if it is designed properly and if it is funded, there's two steps with a revocable trust. We have to create the trust and we have to transfer or move our assets into the trust. So we want to move our non-retirement assets, our residence, our money market checking savings account, savings bonds, mutual funds, brokerage accounts, things that are non-IRAs, we move those into the trust. Now, once we've done those two things, we will not have probate on those assets. And of course, many of you on this call have significant IRAs or 401ks, and you have life insurance. Those types of assets flow in the planning of a revocable trust. They flow in a certain way, but they don't usually go into a revocable trust, especially retirement assets. So a revocable living trust is a substitute for a will. It does not provide asset protection. It does not provide tax savings, although it can be a really nice tool to ultimately provide protection for others, but it does not provide protection for you during your lifetime. So we need to understand that a revocable trust might be a tool to use for certain strategic reasons, but it does not provide for asset protection or tax savings. The cost of a revocable trust and the cost of administering a revocable trust are widely believed to be, I should say, much less than a probate estate. That is generally true because the trust requires, if we really want to structure it properly, it requires us to do a lot of upfront planning. So that's why we can save money on the back end, on the administration side after we've died, we can save money, but only if we make sure that the trust is funded properly up front. So a trust has to be administered similar to a probate estate, but a little bit differently in that the administration is private. So we have administration in probate, we have some administration in revocable trusts, and they're similar but different. And the cost of a revocable trust should, if it is properly done, it should be less than probate. This is an example of a revocable trust. And here you'll see that the revocable trust has taken the place of a will, and that the revocable living trust is the driving force here. So the revocable trust is an alternative to a will. It is not better than a will. It is not worse than a will. It is just another alternative. And here at Elville and Associates, we counsel people about all aspects of planning, including what is better for you, a will or a revocable trust. Now, we can't understand wills versus trusts without also understanding the tools, or what we might call devices, non-probate transfers, that also exist in the world. So most of you on this webinar already understand this intuitively. We have joint ownership, beneficiary designated assets like IRAs and 401ks and 403bs and life insurance. All of those things are beneficiary designated. Life estate deeds are a way to avoid probate, to take your piece of real estate, own it for your life, and then on your death, leaving it to beneficiaries with no probate. Many of you understand transferable on death designations. Many financial advisors are very focused on these accounts. If I pass away, my non-retirement assets go directly to a beneficiary and there's no probate. That can be a good way of doing things, but it can also be a way that we want to avoid of doing things. Because if we have assets flowing in a certain direction, which we're going to look at just a second from now, we could have assets going in the wrong direction, or we could have assets going directly to someone that really shouldn't receive them outright. And transferable on death assets, they go where they go, and they go with no control. So if we want to control assets, we would not use transferable on death. Payable on death is a bank designation for an account. Many of you have payable on death accounts. If I have a bank account, it can be made payable on death. In trust for accounts are similar to POD or TOD accounts in some states. So where are we going with this? Well, I would say there are three categories. We have wills, we have trusts, we've talked about that. Now, in both of those scenarios, we are controlling how our assets are going down to our loved ones. And we are providing for contingencies. Well, I'm leaving it to this person, but if this person is not well, or if this person is disabled, or if this person is not living, here's how those assets are going to be distributed, or here's who those assets are going to go to. But in these designations, joint ownership, beneficiary designations, transferable on death, payable on death, there is no contingency planning. This is very straightforward. If I die, this happens. Now, many times that is going to be okay. But what most people do who are doing planning, they are concerned about planning for contingencies and planning for what ifs in the world. So I would just offer wills, trusts, and then in the middle, I would have this category of non-probate transfers. And I would say very few people would want to have an estate plan that is strictly the non-probate transfer, because the non-probate transfer is useful and it might work as intended, but it also might not work as intended because it has no flexibility. So in our view, as estate planners, we want to use wills or trusts and use the non-probate transfers as tools. All right, this is an example of what I was just saying. We have this wonderful will or wonderful trust. It could be the greatest trust in the world. We went to the greatest estate planners in the world and got these documents. But now we die and look how the assets are flowing. We have a will or trust and we have certain things we want to do with that will or trust, but look at what we did with our assets. Our assets passed straight to the beneficiaries and they are not going to be controlled by the will or trust. So this is a very simple example. I'll give you another slide on this. We have a great will or trust, but the assets just kind of slide right on by the terms and provisions of the will and trust. And that might be okay under certain circumstances, or it might defeat the purpose of our planning. So as you look at the bottom of this slide, this is one of those key fundamental things to take away from this webinar, that arguably the most important thing in estate planning is not your trust or will, but how those assets are owned at the time of death. How we own our assets at the time of our deaths is arguably the most important thing in estate planning. So for those of you who are just getting your feet wet, so to speak, in this kind of thinking, I want you to realize you can have a great will or trust, but your assets have to be titled properly, or otherwise your planning with your will or trust may not work the way you want to. So we have two steps: creating the will or trust, and then making sure we are properly designating beneficiaries. And also, do we need to retitle any assets? For example, retitling assets in the name of a trust. All right, Jeff, we've gotten about halfway through, I believe, and we're getting ready to go into incapacity planning. I'm going to see if there are any questions.
Sure, thank you, Steve. We do have a few, and a couple of them relate to probate, so I want to touch on that for a minute. So the question is the average cost of probate 4% of the estate left behind?
That's a great question, thank you. So I'm just going to say that the Register of Wills has a formula, and it's kind of a strange formula here, and here it is. The fees that are allowable in probate are basically $1,800 of the first $20,000 in probate. And then anything above $20,000 is 3.6%. So $1,800 of the first $20,000 and 3.6% of the amount over $20,000. Now that's how I'm just giving you just for purposes of our workshop this morning, to give you a ballpark figure of 4%. And yes, that is 4% of the estate to be accounted for, or excuse me, the estate accounted for. So in other words, the amount in probate is what is subject to the 4%, or the roughly 4%.
Okay, thank you. Next question, what about beneficiary accounts where the state requires a specific beneficiary, such as a spouse? Can you change or override that in a will?
Thank you. I think, I'm not 100% sure, but I think you might be referring to the ERISA requirements, or maybe state requirements that a spouse be listed as a beneficiary. And if I'm right about that, that means that your spouse would have to agree to waive that right. So, for example, on a 401k, ERISA is going to say my spouse has to be the beneficiary unless he or she waives the right. And you can't waive that in a will. This would have to be done in writing by the spouse, him or herself.
Okay. Next question, what's an example of an asset you'd want to control?
Thank you. So let's say that I'm doing an estate plan, and let's say that I have a child or a niece or nephew or a grandchild, and I want to make sure that that child's share, or grandchild or niece or nephew share, is controlled. I want to make sure that I leave a trust for them because I'm protecting them against bad marriages, bankruptcies, and so forth. I want to make sure that I'm either protecting them or that I'm also controlling their behavior. Maybe I'm concerned that all the money will be gone in 3 weeks after I'm gone. So what I want to do with my assets is I want to make sure that if I had that trust, and this is just one example, of course, if I had that trust for that child or grandchild or special needs child or whatever it may be, that trust is actually going to receive the money that I'm designating. So I don't want to have a situation where I think that money is going to go into this trust to protect my loved one, but now the money goes in another direction. Or the money goes through probate first, and I didn't intend it to go through probate, and now there's all kinds of probate fees or taxes that are due. So another example would be, take the same scenario, and let's pretend I wanted to leave an IRA to this trust. So I wanted to leave an IRA to this trust for a beneficiary, so I want to make sure that that money flows right in there. But let's pretend that I overlooked something I did not have a beneficiary on that IRA. Now what happens? The IRA goes through probate, and now almost all taxes are due all taxes are due within 5 years instead of the taxes being able to be stretched out a bit longer. And as a practical matter, all taxes are due immediately because the executor is really just going to cash out the IRA. My last example would be someone who is charitably minded. They want to leave an IRA to charity, but instead they left the IRA under their will through probate. So they could have left the IRA straight to charity, and the charity would not have paid taxes on that IRA, but instead it was left through probate and all taxes were due, and it was terribly inefficient. So those are 3 or 4 examples of hopefully answering your question about controlling assets down to the beneficiaries.
Very good, thank you. Just a couple more if we have some time. And how would it work with real estate in retitling in the case of a will versus a TOD?
Well, TOD would not apply to real estate, even though there are some jurisdictions that have what is called a transfer on death deed, basically. But a life estate deed is similar, in my mind, to having a TOD designation. It's not really a TOD designation. So hopefully I'm answering your question by saying that if I have a piece of real estate and I say to Steve owns it, but now I'm transferring it from Steve to Steve for life. And I have the right to live there. I have the right to sell it because I didn't give up the right to sell it. But at my death, it goes no probate to my remainderment. It goes to my children, let's say. That's a way of avoiding probate. Versus if I had a revocable living trust, I would take that piece of real estate, I would put it in the trust, I would retitle it into the revocable trust, and now my trust is controlling that real estate down to the beneficiaries, and that's going to avoid probate as well. So hopefully I'm answering your question, at least in part, that in a life estate deed, it's kind of similar to a TOD, no probate, but there is no control. If I leave it down to beneficiaries who have predeceased me, then their estate is going to control where that goes. So the property could end up with a son or daughter-in-law that I didn't want it to end up with, and that kind of thing. So we use the documents or trusts to control how assets go down, although sometimes we can use simple techniques like a life estate deed or a TOD.
Okay, and then one more. I know we've got a lot to cover still. Is a trust somehow at less risk of challenge versus a will?
That is a wonderful question. Thank you. In the old days, when I was much younger, a lawyer, I used to think that. But the truth is that a trust is subject to just as much challenge as a will, but and that's a legal answer. Now, practically speaking, my view would be that a properly drafted trust is probably a little bit less subject to challenge, because the beneficiary who's challenging, or the person who is left out that's challenging, the person that would have standing to challenge, that person would have to bring the challenge in a circuit court rather than in the orphans court. So let's say this person was challenging a will. In my view, they could very easily challenge the will because all they have to do is object. And if they have the rights of an interested person, meaning they have standing, they can object very, very easily and cause trouble. I'm not saying they would win, but they can cause issues. A person who is using a revocable living trust and making sure that there is no probate, that person, to me, is doing everything they can to avoid a challenge. And if there is a challenge, the person who's challenging has to jump through hoops in the circuit court, meaning they have to go through the formal rules of evidence in a much higher court, and that's going to be more difficult for them, and it's going to be more expensive.
Very good, thank you. That's everything for now. Lots of great questions. Thanks, everybody.
Thank you, everyone, and thank you, Jeff. Now we're going to move into not a very exciting subject, but a very important subject, and that is understanding incapacity planning. So as I mentioned earlier, many people are living very, very long lives. I had a client live to 106 a few years ago. arguably, the powers of attorney, the financial powers of attorney, are the most important of all documents. Why? Because the financial powers of attorney give someone flexibility. If I'm going to live a long life, hopefully, I'm going to need flexibility. Now, flexibility is not for everyone. Many powers of attorney are extremely broad, and it might be eye-popping to some of you about how much power you can actually give someone. So we counsel people through these issues, and I believe it's maybe safe to say that Elville and Associates is one of the only firms I'm aware of that actually goes through powers of attorney in detail with clients and advanced medical directives. But again, that's my perception. But these documents we want you to take very seriously because we want to avoid the issues associated with what? Guardianship. We don't want you to ever be the ward, God forbid, of a guardianship unless it was absolutely necessary. Because if we lose our legal rights in guardianship, that means the circuit court and the guardian are in control of our lives, they're in control of our person, and they're in control of our property. So incapacity planning, hugely important to provide for flexibility. Advanced medical directive is arguably, for some people, excuse me, I'm getting ahead of myself, they're arguably the most important document to them. I think in the estate planning world, it's safe to say that from a planning perspective, powers of attorney are kind of the Swiss Army knife of incapacity planning. And both of these, again, extremely important to avoid guardianship. Now, you'll notice as we get into these slides here about the statutory power of attorney, you'll notice here that Maryland has a statutory power of attorney. It's a simple form. There is the short form, which is only about 5 pages, and then there's the long form, which is literally a long statutory power of attorney. These are very, very good things in my view because they help cut down on fraud and abuse. In 2010, the Maryland Power of Attorney Act came out and basically said to the citizenry of Maryland, you can have a power of attorney that actually works. And we don't have to worry about fraud and abuse, which was occurring on a wide scale. So the statutory power of attorney is a very straightforward form, but it's not supposed to be customized. It is what it is, and Maryland wants everyone's statutory forms to be what? Enforceable by law. So if you are ill and your agent goes to use this power of attorney for you, you're the principal, they are the agent should expect that that power of attorney will be accepted and they have the power to enforce it. So this is a very important thing at a time of crisis. So remember, powers of attorney, advanced directives are there at a time of crisis to avoid guardianship. But the statutory power of attorney is, in our world, not enough because it is a simple form. DC has one, New York has one, West Virginia and Delaware have it, and there are of course other states that have it. These forms are for the average person. Now let's think about this. This is for the average person. It's for you and I. It's for the person who comes in and works on our house construction. It's for the person who does our taxes. It's for everybody. The person who works at a convenience store. The state of Maryland wants you and I and everyone to have a power of attorney that works. Now, here's a question for you. If you are doing estate planning, are you an average person? And the answer is no, because we know that most people don't have estate planning. So the average person doesn't even have an estate plan. So the statutory power of attorney is what I'm trying to say here is important, but it is not enough. It is a simple power of attorney. Now, the broad power of attorney that you'll see if you research this issue, the long statutory form is a very substantial power of attorney. But we can't really customize those forms. So what most estate planning attorneys do in Maryland, not speaking for all, but just for us, they use 2 powers of attorney. They use the simple power of attorney as a basic tool because it's enforceable by law under the penalties of attorney's fees, but they also supplement that with a general durable power of attorney that is much broader and provides for estate planning powers. So the next slides are really just about the statutory power of attorney and why we would not consider that to be enough It is not broad enough. It is not flexible enough for estate planning needs. And so I'm not going to spend a lot of time on that because we want to make sure we have more time for questions at the end. But just take my word on it that for right now, on faith, if you would, that the statutory power of attorney is a simple form. It's effective, it's important, but it does not cover everything. Now, many clients consider the advanced medical directive to be the most important thing. We are huge proponents here, as all elder law attorneys are, that advanced directives should be not only implemented, but they should be customized. Now, do you have to customize your advanced directive? The answer is no. You could just basically fill out a form, insert your basic preferences, and that's fine. We encourage you to take a little bit more time and try to customize this with your personal preferences, your food preferences. How would you communicate if you were in a facility? What do you want? Do you want your relatives to visit you every day? It may sound simple. It may sound very tedious, but think about this. The advanced directive is really the only thing your loved ones or your agents have that would evidence your personal preferences unless you told them these things during your life. So we want to provide flexibility, generally speaking. We want to customize this to whatever degree. There is no such thing as only one advanced directive. There is no such thing as only the Attorney General of Maryland's advanced directive or the Attorney General of Virginia, their advanced directive. An advanced directive is informal. It's an informal document, and it can actually be customized. There are forms out there. There's a form called the 5 Wishes that some of you are familiar with. There are Catholic-related forms and so forth, and other forms. So just know that we use the Attorney General's form because it is easy to read and most people can understand it in the very short term looking at it and trying to evaluate what a person wants. And it's readily accepted in the DC, Maryland, Virginia area and Delaware. So understanding this advanced directive is very important and taking the time to customize it. The MOLST form, the medical order for life-sustaining treatment. If you've never heard this, don't be stressed. This is now a part of the fabric of healthcare decision-making in Maryland. It is required by law. If you or I go into a facility, we have to have one of these forms completed by a doctor or a nurse practitioner within 48 hours. So there's a lot to discuss about MOLST. Just understand that if I were you and I were trying to take this in today, I would note mentally, this is something that's required in Maryland. It's a part of healthcare decision making, and it's something that you're going to want to educate yourself about, and you're also going to want to educate your agents, your children, your trusted agents. All right, so we've talked about the basics of estate planning. We've talked about the process of estate planning and why the process is essential. We've talked about having a goal. We've talked about all the reasons why people plan and why we have to worry about whether plans are actually going to work or not. We've talked about maintaining the plan. We've talked about wills versus trusts. We've talked about powers of attorney and advanced directives. So now I'm going to go further now into more of the weeds, so to speak, more into the technical side of estate planning. So we're going to go through a few bullet points here. So what is the current tax environment? Well, there's never been a better time to do estate planning from an estate planner's point of view than there is now. And that's because we have very favorable income tax laws, generally speaking, for estate planning. And we have unprecedented, as we see here in the second bullet point, we still have unprecedented exemption amounts. So in other words, if you die, you can leave $12 million, that's right, $12,060,000 free of estate tax. And if you're married, your spouse can leave $12,060,000 free of estate tax. If you want to gift during your life, you can gift up to $12,060,000. So we've never seen exemption amounts this high. Last year in 2021, these were 11.7 million, but now they've been adjusted for inflation. Maryland's estate tax exemption is still 5 million. Now in 2021, Congress was considering, and many people on the left, Senator Sanders, Senator Van Hollen, President Biden, and others, they were pushing an agenda to cut the estate tax exemption and to actually take away the tax advantages of what is called the step up in basis at death, or the cost basis at death adjustment. This would have been very, very big. So thank goodness it did not happen. There was a lot of fanfare and a lot of discussion and a lot of anxiety about these things happening in 2021, but they did not. So we still have these unprecedented amounts. We still have very favorable income tax laws for estate planning. And Maryland, again, still has a $5 million exemption. Now, Maryland is one of the only states that still has an estate tax, meaning a state estate tax, and an inheritance tax. But inheritance tax of 10% does not apply to you if you are leaving assets to lineal descendants. If you're leaving assets to nieces and nephews or beyond, then the inheritance tax will apply. The only good news is that if you end up owing inheritance tax, you get a credit for the inheritance tax paid against the estate tax in Maryland. Now, despite all the talk in 2021, which we cannot possibly even start to even fathom in this discussion this morning, there were so many potential changes that were going to occur, so much change that Congress wanted to change about the estate planning laws and the tax laws. But the one good thing that we can rely on is if you're married, Congress does not seem to be interested in taking away the portability exemption or the use of what is called the deceased spouse's exemption amount. So if you are married, I apologize if you're not married, this doesn't apply to you, but if you are married or you are a surviving spouse, then portability was something that you can choose within 24 months of your deceased spouse's passing. And portability just means this: if I'm a surviving spouse, I can choose to use the 12 million exemption of my deceased spouse. In other words, I can use it, and I can also use my own exemption at my death. I can lock those things in. So portability seems to be here to stay. It's a simplified way of doing estate tax planning. And why is estate tax planning a big deal? Because estate tax is 40%. Some on the left wanted to get it up to 55% again, but and that's what it was when I was a young lawyer. It's still 40%. Okay, in the interest of time, I'm going to keep going down this list. Marital control. If I'm married and I'm doing estate planning, I can control the assets. So some of you may say, well, you know, I'm not young anymore, and my spouse and I have been married a long time. But notwithstanding that, whether I've been married long or short time, I want to control the assets. If I die first, I'm not leaving everything to my surviving spouse. I'm leaving it in a trust for my surviving spouse so that I can be assured that at his or her death later on, that this will go down to my beneficiary. So we can exercise control over assets. We can actually protect against remarriage. There are reasons why that in Maryland, something called the new spousal elective share is in the law. So if we want to make sure that assets don't go to a new spouse, as much as that's either funny to talk about or not funny, usually we laugh about that. But if we remarry, even if we thought we weren't, but we remarry, we want to make sure we're protecting the assets for our kids by having a premarital agreement. That's the best defense, where the new spouse waives his or her rights of election and so forth. So we're worried about marital control. We're worried about remarriage protection, not for younger people, but for older people generally, this is a concern. For young families, people that are 45 and under with young children, this is generally not a concern. The children and guardianship, guardians for the children are the main concern. Now, I'm going to switch gears here to long-term care and Medicaid. So we're talking about elder law now. We're talking about the difference between estate planning and elder law. What is the difference? Well, in a nutshell, estate planning is concerned with the disposition of assets, wills versus trusts, tax planning, making sure that all the bases are covered. Elder care planning, on the other hand, is basically estate planning for those who are over 65 or 70 years old, and arguably people over 60. So elder care planning is a type of estate planning that is similar, but basically it has a focus on disability planning. Disability planning, long-term care planning, planning for nursing homes, costs, God forbid, the cost of assisted living, long-term care, insurance, hybrid policies, and so forth. A hybrid policy that can be put into a life insurance policy, all of a rider, I should have said. All of these things are part of elder law: housing, social security, special needs planning. So all veterans benefits, all of those things are part of elder care versus typical routine estate planning. So again, elder care sometimes and many times is focused on asset preservation. Is there a way for me to preserve assets from a nursing home spend down? So the answer is definitely yes on the in the current law. Is there a way to preserve assets while still providing for flexibility for me? Is there a way that I could, if it's my goal, because remember, goals drive everything. So if I want to divest my assets, if I want to give away my assets so that I can avoid a nursing home spend down, can I do that and still have the best of all worlds? I can still be in somewhat of control of those assets. Can I have that flexibility? The answer is yes. Remember powers of attorney. Remember I said powers of attorney are arguably the most important of all documents. Well, in elder care, I would argue that is absolutely true. With a properly drafted, flexible power of attorney, your agent can have tremendous flexibility to go in all different kinds of directions to accomplish your goals, especially if your goal is to preserve assets. So again, we can do what we can envision that we want to do to preserve assets, still maintain some control, and we can hit several birds with one stone, so to speak. This is done through Medicaid planning or Medicaid trusts, veterans trusts. These are designed for certain purposes. The Medicaid trust, I would say, again, is the Swiss Army knife of elder care planning along with powers of attorney. It's an extremely powerful tool, but these are some of the differences between typical estate planning and elder care planning. Now, I'm going to move a little faster because I want to leave some time at the end. I would normally stop here and take some questions, but with your permission, I'm just going to keep going. One of the big issues in the world today is asset protection. Most people kind of intuitively understand this, but they don't really understand the various types of asset protection. So I'm going to break this down into 3 categories. So we're going way beyond basic planning now. We're talking about asset protection. So hopefully this is valuable to you. Lifetime asset protection. What is the protection we already enjoy in some of our assets that we may not even realize? Long-term care asset protection. We just talked a little bit about that. We're going to talk about that again. And asset protection at death. How do I make sure that my loved one is protected at my death? Protected from what? Protected from the claims of creditors, bankruptcy, a bad marriage, and so forth. Unforeseen things like a bad contracting arrangement, and so forth. If you're married, you probably own your home as tenants by the entireties, spouses, spousal ownership. That means that you have a basic layer of asset protection, so you cannot lose your house if one of you is sued. Now, if both of you are sued, there is no protection, but it is a basic layer of protection. We strongly encourage you, if you're married, to examine all of your non-retirement assets, stocks, bonds, mutual funds, and see if you can get as many of those titled as tenants by the entireties as possible, because Maryland is a very big tenants by the entirety state, just like Delaware is. Life insurance is protected from the claims of creditors if your child or spouse is the beneficiary. Annuities are protected in the same way. Spouse or beneficiary or child is the beneficiary, I should say. Qualified plans, 401ks and 403bs and 457 plans and IRAs are protected from the claims of creditors. So if you didn't know that, now you know. If you leave an IRA for a child grandchild, other person other than a spouse. Those IRAs are not protected from creditors generally, and they have to be left in a trust so that they are protected. Now, this is not a revocable trust. This is a trust at death, which we're going to talk about in just a few minutes. So these lifetime asset protection concepts are very important, but this is not usually what people are focused on, and that's why I wanted to make you aware of the different types of protection. Now, in Medicaid planning, or what we call elder care planning, we again use something called a Medicaid Asset Protection Trust. It's not for everyone, but it is a very, very powerful tool to be able to give away assets, if that is your goal, to give away assets and start the Medicaid 60-month period, the Medicaid 5-year look period. Many of you will think in terms of a 5-year look back. I'm going to encourage you to think about a 5-year look forward. If I give away assets and I don't apply for Medicaid for 5 years, in the future, those assets under the current law would be protected from a nursing home spend down. You can also maintain a modicum of control over these assets after you have transferred them to the trust. Veterans trusts are similar tools designed to help someone get qualified for veterans benefits, meaning the veterans aid and attendance benefit. In 2018, the VA made the veterans benefit more difficult to get, although there are many different types of VA pensions. But it is still possible to get this pension, and there are strategies to get it. Wills under trusts, the use of trusts under wills, that's what I meant to say. The use of trusts established under wills, this is an essential strategy in elder law. In 1993, Congress authorized that if I leave a trust at my death for my spouse under a will, the money that goes into that trust is going to be exempt from a nursing home spend down. So I would have to die to do that, but that is a very powerful strategy. So some couples that are dealing with a situation like a dementia or an impairment like Parkinson's disease, some kind of long-term illness, we sometimes will use these trusts. Now, we talked about the new spousal elective share law and how we want to protect against remarriage. That's called the augmented estate, considering the entire estate and not just what goes through probate. Well, the good news is that as part of that bill, there was a compromise to where if we leave under this will that we just talked about, I die and I leave a trust established under a will. If I do that in a certain way in accordance with Maryland law, then Maryland can never recover against that. So if I leave that to my spouse in that trust under my will, Maryland will have no recovery about that. So we talked about the 5-year period. What's important to know about Medicaid planning or elder care planning today is this. Properly planned, we can avoid losing money to a nursing home spend down if we give away assets 5 years in advance. If we do not give away assets 5 years in advance, we could still save about more or less 50% of the assets. And that's what the rule of halves is about. We either save all of the assets in a 5-year look period, divesting assets, or if we don't divest assets in advance and we have a crisis, then the rule of halves would control and we can still save about, in most circumstances, about 50%. Life estate deeds can also be used. There is such a thing as a life estate deed with no powers. You'll notice in the prior examples that I talked about a life estate deed with the power of sale. I have the property for life, but I've preserved the power to sell. Well, if I give up the power to sell, I'm now starting the 5-year period because Medicaid says if I give up the power to sell, my beneficiaries, my remainderment, they already own it because I gave up the power to sell it. So that's a powerful tool. So just know that this slide, which we went through pretty quickly, this slide represents some of the elder care strategies that can be employed. And this is part of what I would say is an elder law consultation to decide what to do in a certain circumstance. And for those of you on the webinar this morning that are essentially here to try to learn about how to do a will or a trust, I apologize. This is really about those on the call who want to learn about the basics of elder law. We're almost done. Now, one of the last aspects here of asset protection, I should say, is asset protection at death. So we talked about planning for spouses. If I want to control assets at my death so that it goes to my spouse in a trust, I'm controlling how that goes down to children. Well, here, part of the reason I would use that trust or leave assets into a trust for a spouse is to give them protection from creditors, protection from bankruptcy, protection from a bad spouse in the future. So I can not only control those assets, but I can also protect them. And I can do the same thing for children and grandchildren. So a spendthrift protected trust, and what we would call a spendthrift irrevocable trust, is a trust where the beneficiary is protected by a spendthrift clause. The beneficiary does not have the right to give away or assign those assets to a creditor, so therefore the trust has integrity and it protects those assets. Beneficiaries can be in control of their own trusts. That has its benefits in certain ways, and it has other downfalls, but there are ways of doing it. Maryland allows a trustee to be their own, or the beneficiary of a trust to be their own trustee, is what I'm saying. So we have to think a lot about structuring trustees. There is a special fiduciary called a trust protector, and Maryland calls that a trust advisor. So we want to make sure we've thought through those issues. Powers of appointment, those are where we can decide whether the beneficiary has any control over where the money goes in the future. And there are pros and cons about how we do that. And also, of course, protecting special needs beneficiaries. Very straightforward to do, very easy to do, but very important to not overlook. Now, the Secure Act, as we start to wrap up, the Secure Act came into effect in January of 2020. And what does this mean? Well, it means that it could affect your estate plan. If you have an IRA or a 401k, and you're going to eventually leave that IRA or 401k to someone other than a spouse, the Secure Act is probably going to be affecting you in a big way. It basically means that assets are going to be taxed for most healthy beneficiaries. The IRA assets are going to be taxed in 10 years or less. So this is not good for families. It's not good for beneficiaries. It's going to accelerate taxation. But the good news is there are 5 exceptions, and I'll go ahead and tell you what those are. Those are the exceptions for minor children, spouses, people who are less than 10 years younger than you, which is a strange exception, people with disabilities and a special needs trust and their special needs trust, or people with chronic illnesses and their special needs trust. Those people are exempt, and they can continue to use a very advantageous stretch out of the taxation for their entire lifetime. But those of us who are not in those 5 categories, then we only get 10 years to stretch out the IRA. So this is something that has to be considered. There are certain strategies to be employed. You may or may not ever want to use those strategies, but we do have to acknowledge that a lot of taxation is going to hit beneficiaries after our deaths because of the Secure Act, and it's going to be accelerated taxation. Now, Elville and Associates has a client care program. We talked about process. We talked about having an estate planning process rather than randomness that can occur in estate planning. So these slides are inserted. Jeff, thank you very much for putting these slides in. These slides are to illustrate that Elville and Associates, remember, we want to educate, but we also want to provide a path forward. So we're not only going to give you some suggestions today about how to move forward, but we're also going to tell you that part of our process is to be able to make sure that clients can continue to update their planning. Because remember, the first step is only one of the steps of our process, but we want you to think in terms of a lifetime approach, not just a one-step process. So our client care program, we're very proud of this. We have lots of members who enjoy the client care program and its benefits. And basically what we are doing is we are encouraging, that's all we're doing, we're just encouraging clients to continue to update their planning over the years. So remember, that when you do planning and you design it properly and you have the time to think, and we make sure that we have your assets properly situated, properly aligned with the estate plan, and if you maintain and update your estate planning over your lifetime, and you don't have to go crazy with this, but it has to just be a reasonable approach, and that's why we have this client care program to encourage people, then we know that at our deaths, it's very likely that our plan is going to work the way we envisioned it to work and the way we designed it to work. So use these as tools. Jeff may make a few comments about these, but this is just to give you an idea of our client care program, and it is to encourage people as part of our process to continue to update their planning. All right, as we just get through the benefits of our client care program, we're going to end now and see if anyone has any further questions. But I want to encourage you again with a path forward to set a consultation with us and sit with us, and we don't charge for initial consultations. That's our policy here at Elville and Associates. Sometimes with elder care issues, we charge hourly, but for estate planning, we do not charge to review existing estate planning documents or to sit with clients, and we set aside an hour and a half, 90 minutes for an initial consultation, and there's no charge. So we want you to complete an estate planning questionnaire so that we know more about you, and you start to participate in this process of working together towards your estate planning. We want you to relax and understand there's nothing to fear. We understand this is not easy, but we're here. We have spacious conference rooms with lots of tools and electronic tools to help in the illustration process and in the planning process. We want you to bring your existing estate planning documents if you already have some. So we want to review those, and we don't charge to do that, generally speaking. And we want you to consider whether you have a planning team. Do you have a CPA or a financial advisor? Do you have what we would call a collaborative team? Because we want to work with your team. We want to be your planners for life, so to speak, and work with your advisory team. If you don't have an advisory team, then we want to help you obtain one, and we can help do that. We want you to prepare questions you may have. You may have questions, and if you have the patience and time to sit down and bring those questions with you and write them down and type them out, we love that, and that helps our consultations go quicker or more efficiently to be able to answer your questions. And as Jeff and I mentioned earlier, we want to give you the time to think. We want you to decide what your goals are, what you're doing, what are your purposes in the planning, and the things that are driving you to do planning, to give you peace of mind and know that things are going to be in place for you. So I think we've been successful to leave at least 7 or 8 minutes for questions. I thank you for sitting through all that information. I hope you'll use this as a tool. Remember, we're here as a resource for you. We believe in education and family education, and we thank you for taking your time this morning on a Friday morning, and I wish you a wonderful weekend ahead. Jeff, I'm going to turn it back to you.
Well, thank you, Steve. Appreciate your time and expertise as always with this presentation, which we try to offer at least once a month. And if you just can't get enough of our estate planning essentials, we're actually offering it again on Tuesday evening at 7 o'clock. So if you want to come back and join us again, Tuesday evening at 7 o'clock, we'll be back here in the same seats doing it again. So you can sign up again and listen again and learn a little bit more. So, but now would be your time for this presentation to get those last questions in if you do have any. And I think we probably have a few here that I'm going to go through with you, Steve.
Very good, Jeff.
So it says here, the first one, I've heard the laws in the state you die in apply. So I guess I should plan on where I die too. Is that correct?
Yes, thank you. If I understand that question, I think you're saying if I reside in a certain state, that's going to control, the law is going to control my will or trust. And that's going to generally be true. With probate, it's definitely going to be true. With your revocable trust, if you move to a new state, you're going to want to make sure that your revocable trust is also moved to the new state. But you could have property in other states. So you could have an estate in this particular state, state A, let's say, but you have property at Estate B as well. So there might be what we call an ancillary estate. So that estate, that state property, I should say, will be controlled by the laws of that state. So you're going to have a primary estate where you live, and if you don't own any property in other states, it's all going to be controlled by the laws of that state. So I would agree with you there.
Very good. Doesn't look like we have any further questions here. So I'm going to make a couple of brief last comments here. And so now would be your time to get those last questions in. I guess I would also just say I'm obviously not an attorney, but you know, we have thought a lot about that concept of giving you time to think. And you know, it takes time for people to consider consultations and coming in to see us. And but we would encourage you to come in for a consultation. You don't have to have the solutions to your planning at this point in time. You know, coming in to talk with Steve and talk with our team it is a great first step. And as I mentioned at the very beginning, it's our job here to help you create those solutions to your needs, you know, based on what you share with us. So if you've got a lot of questions rattling around in your mind, what about this? I don't understand this. You know, that's part of the initial consultation, and us getting to know you and you getting to know us better and understanding your situation. That's what I think really Steve is really great at, is crafting a solution to meet your family's goals and situations. So that's just all I'll say about that. So we do have a question related to that. So what documents do you need to gather when getting started, Steve?
Thank you. If you have an estate plan already, if you have a will or trust or powers of attorney, we'd like to see those existing documents and make copies of them so we can review them and let you know what we think about them. If you are a person who does not have existing documents, then you don't have to bring anything with you on your initial consultation other than hopefully a questionnaire that you've completed from Mary Gay Kramer, my assistant, and she works with all of our estate planning team here. And we want to just see your basic overview of your personal and financial information. However, if you're very proactive, that would be wonderful if you could bring in statements and a spreadsheet of your own if you've created one, or just financial brokerage account statements and retirement plan statements, life insurance policies that you may have. That would be very helpful, although you don't have to do that on the first visit. Thank you for that question.
Okay. So while we get any final questions in, I'll just say I always try to send out a comprehensive, follow-up email to everybody, kind of reviewing what we talked about. And so what I'll send out very soon after this presentation is a video from today. So if you want to review what we talked about, you'll have that. Copy of the MOLST packet that we share with people for your review, which typically brings up several questions. Also, a copy of the slides. Also, regarding our wellness, our webinar series, I should say, March 8th, we have a brand new topic we're really excited about that people have been asking for a long time: financial exploitation, frauds and scams targeting seniors. We already have a record number of people signed up for that presentation, from Mr. Andre Lingham. He is the founder of the Center of Elder Justice and Education, two-time Howard County Police Officer of the Year. Just an amazing man I've had the privilege of speaking to. He's going to be speaking to you on March 8th, and also on March 22nd, going to be talking about identity theft, the illusion of privacy. So I'm very excited about that mini series that Mr. Lingham is going to be bringing to you. Also on March 15th, we have our wellness series, which is part 6 already, with Dr. Michelle Fritsch and Miss Ellen Platt, an aging life care manager, talking about keeping your brain active and healthy. That's something we're going to keep rolling along here in 2022. It's been very popular and successful. And also, don't forget, if you want to come back for one more estate planning essentials, we are going to be here on Tuesday night at 7 o'clock. And there's not an online registration for that. It is in partnership with our friends at Timmick Financial. So you'll have to give them a call. There's information on the website Elville event, elvilleassociates.com/events, and you can call them and register for that presentation. And, oh, okay, so a question, how can we get a list of your upcoming webinars to refer to for later, because it seems you have many relevant topics? Well, thank you, yes. So go to elvilleassociates.com/events. You'll see all of our events. If you are on our webinar here, you should be getting invitations on a relatively recurring basis related to our upcoming events. If you're not on our mailing list, let me know and I'll be sure that you are. Typically, I ensure that all of our attendees are on our mailing list. So if you're not on there, let me know, please. So that should just about do it for today. Let me make sure I haven't missed any questions. And it is 11:30. Okay, one more question, then we'll, I think, call it a day here, Steve.
All right.
So to clarify, does it make sense for me to consult with you for an estate plan if I live in Virginia, or should I see an estate planning professional here in Virginia? That's a question we get pretty frequently.
Thank you for that question. So I personally am not barred in Virginia. We do work with a Virginia attorney, or maybe I should say more than one, and it depends on where you live in Virginia. We can help clients do estate planning in Virginia collaboratively. Some people want to do that, and some people, depending on their preference and depending on the geographics, just prefer to work with a local attorney in Virginia. So we are happy to help you either way. But in any event, we would be collaborating with a Virginia attorney, at least in part. So thank you for that.
Okay, I think those are all the questions here. We thank you for your participation today. Steve, thank you as always for your time and being a great resource. And we look forward to being a resource to you soon and seeing you again on one of our upcoming webinar series topics. We'll see you again soon. Have a great weekend, everybody. Thanks.
Thank you.